Hello friends, in the series on the income tax cases, today we will discuss a very important case on penalty under section 271 subsection 1 clause C. The name of the case is BABITA DEVI KAJORIA versus Income Tax Officer. This case has been reported in 101 ITR Tribunal short notes 17 and the matter has been decided by KOLKATA ITAT C bench. The date of the judgment is 22nd December 2022. In this case, the notice for the assessment year 10-11 under section 148 was issued to the assessee on the ground that the assessee has claimed a wrongful loss of rupees 4,78,000 rupees. When the assessment was going on, the assessee didn't cooperate in the assessment proceedings and the assessing officer made inquiry under section 133 subsection 6 with the National Multi-Commodity Exchange and got the information in regard to that notice under section 133 subsection 6 that the assessee has earned a gain of 11,53,000. So the assessing officer made the best judgment assessment under section 144 and made the addition of rupees 11,53,000 rupees. The assessee went into the appeal. CIT appeal also confirmed the order or the demand which was being made by the assessing officer. The assessing officer also initiated the penalty with the assessment order, but in that penalty notice it was not clear that whether it is for the concealment of the income or whether it is for the furnishing of inaccurate particulars. And even the assessment year was wrong in that notice. As soon as the CIT appeal confirmed the demand, the assessing officer confirmed the penalty. Assessee went into the ITAT for the quantum appeal and for the penalty with the CIT appeal. While the quantum appeal was pending with the ITAT, CIT appeal also confirmed the penalty. So the assessee went to the ITAT for the penalty order also. Now there was discussion on the penalty order. ITAT said that in this particular case, since the basis of sending the notice under section 148 was wrong and on that basis no addition was done, so no other addition can be done on other ground. Or in this case it was clear that the reasons for which the notice was sent to the assessee was non-existent and there was no application of mind by the assessing officer while passing the assessment order and while issuing the notice under section 148. Because the very basis of sending the notice didn't form part of any addition of the assessment order. So the ITAT said that there is very good chances that the assessee will get its case into the quantum appeal also. So the penalty order is required to be deleted by the ITAT. So this was clear that the assessee was very strong on the quantum appeal. So the ITAT deleted the penalty. But a very important observation was being made by the ITAT that until and unless the quantum appeals are decided, until then the appellate authorities should not confirm the penalty or should not pass the penalty orders. ITAT said that under section 271 subsection 1 clause C subclause III there is a methodology of calculating the penalty which is dependent upon the quantum of demand. So until and unless the quantum of demand is confirmed by the higher courts, the appellate authorities should restrict their hands, whether it is CIT appeal or ITAT, in passing the penalty orders. At the same time, the ITAT also said that although there is no embargo on the assessing officer in passing the penalty orders if the quantum appeals are pending. But we have seen that once the CIT appeal confirms the quantum appeals, the assessing officer passed the penalty orders in favor of the department. But the message of this case is that if the quantum appeals are pending, then the CIT appeal or the ITAT should restrict themselves in not passing the penalty orders. Friends, this case is very important as far as the passing of the penalty orders by the CIT appeal or the ITAT are concerned. At the end of this deliberation, once again I am repeating the name of the case. The name of the case is BABITA DEVI KAJORIA versus Income Tax Officer, and this case has been reported in 101 ITR Tribunal, short notes, page number 17. The matter has been decided by Kolkata ITAT C bench and the date of the judgment is 22nd December 2022. Thank you, friends.